Hello, a very warm good morning to everyone. I welcome you here for this last session. I would say on for the case studies and the recent amendments in patent rules. Uh, we'll be discussing this in the context of the Viva voce examination that is scheduled for 11th, 12th, and 13th of July. And this is based on the request of some of the students. We'll be including the amendment part actually that has done since 2018, and we'll also be discussing few important case studies. As such, there is no I would say specific guideline for the case studies, which case studies to be selected, or that way randomly the case studies may be asked. But again, how to answer those case studies kind of question is also very important. Just a request to everyone, if you have any queries, put it into the put it in the chat box. Actually, I can access the chat box on YouTube, and I'll be taking the appropriate questions at the appropriate time or at the end. So accordingly, we will move ahead with this session. Okay. As far as Viva is concerned, those of you who had the access, or who accessed my earlier video on preparation of the Viva voce actually for patent agent examination, which included the strategic part, wherein how should you strategize for this was exactly 2 weeks back. How to strategize in terms of your studies for 15 days, what all you should cover, what all you should not cover actually. And thereafter we also had almost 10 sessions of mock Viva, wherein we had a daily 2 to 3 different types of mock Vivas. So we almost covered 25 to 30 students. So when you have gone through that process itself, although you may not have appeared for the Viva, but then when you have attended those sessions, and that is something which would be really useful for you when you face the Viva. I also got some queries about what all should be we'll be carrying actually at the Viva voce examination at patent office. You have to carry hall ticket as well as your ID proof. I think that these are the only two essential things. All right. And there have been a lot of questions about the dressing attire as such. And I have repeatedly told this, that you should be in formals, normal. I mean, no need of uh, any special, I would say, dressing per se beyond formals actually. Okay. Those who are coming to Mumbai for the Viva, just ensure you are reaching a bit early, because in Mumbai it's raining since last few days heavily. As well, the area in which the patent office is there, uh, like you know uh, the surrounding area, at times the science circle and all is at times, there is a water logging. So ensure you are reaching a bit early as such, if you have Viva in Mumbai patent office as such. Since I'm based in Mumbai, this is just an instruction. Okay. Also, last 10-15 days have given us, I would say, a lot of insights into Viva when we were discussing through our class actually. And we had professionals from different domain, many students who had already appeared for the previous Vivas as well. We tried to cover most of the topics, but then randomly, the questions would be asked. But then the most common questions as well were covered in the first session that we had a couple of weeks back via YouTube Live. Today, we'll be discussing only two things, more technical, I would say, rather than strategic. But these two things are essential, and there are reasons, I would say, for why these two things, or two aspects actually, I would say. One is the amendments actually. Now, generally, in the Viva, like, any general happenings or what we call GK about the patent law or IP is asked actually. Again, when we say that last patent agent exam ke baad, last patent agent exam we had in the month in the year 2018, after that whatever happened is something which is, I would say, crucial for you to understand or remember, so that like, it can be asked actually in the Viva, and at least you should have some fair understanding, or like, for that actually, like, for those. So anything that has happened after 2018 patent agent exam, those things can be asked in Viva, as well as so that is in on the front of patent office, the regulations, the rules, as well as the act. And on the other hand, it would also be about the case laws that have happened, the recent case laws actually. When we speak about case laws, I mean, there is no general guideline, and you can't say that there are so many case laws happening day in day out actually. So many verdicts are coming, some of them at patent office, controllers decisions for, let's say, pre-grant or post-grant, or there are a lot of cases that are happening in the court as well, like, there are decisions coming. But then uh, when we think of these case laws, remember that these are asked in the context of patent agent, more of a technical, less of a legal perspective or legal point of view actually. So if the case law is also asked, you don't need to much go into much details of the legal aspect as such. What is expected is generally three, four things actually. What is the case law? Uh, if you know the parties, when was it actually, when did the verdict, uh, when was the verdict given, as well as what is that outcome, and how is it impacting the practice. I think this is very significant as far as the case laws are concerned. uh, there is also one more video on Pharma Literati YouTube channel. In the month of February, we had discussed few case laws, as well as we had discussed about some changes that have happened at the Indian Patent Office in the context of IPAB and the IPAB and the Delhi High Court IP. So you can go through that video as well, because there are two case laws and a couple of changes at the IPAB and the Delhi High Court IPD that are covered there. And I'm not going to repeat those cases as such, but as I mentioned, today I'll be discussing some other cases. Let me just open this. Yeah. So I'll be discussing few other cases, case laws, as well as the amendments that have happened recently in the Indian Patent Act. Now, let us start with the recent amendments actually. Uh, there have been 4 amendments actually since last patent agent exam, and these amendments are into the rules and not the act actually. Okay. Also, the Patent Act is 1970, the Patent Rules 2003. The amendment is in these years. With 2019 we had 1 amendment, 2020 we had 2 amendments, and 2021 we had 1 amendment. Beyond that, the IPAB was dissolved, Intellectual Property Appellate Board, and the Delhi High Court IP division was created. This, as I have made it in red, these are already covered in one of the videos which is available on our Pharma Literati YouTube channel. You can just go through that. Now, when you have a question for amendment, generally amendments, then you can mention about 4 amendments. The 2019, 1 amendment in 2019, 2 amendment in 2020, and 1 amendment in 2021. What are these related to? I have just put it in the like, you know, a simple one liner just to remember it actually, like, you know. So the 2019 rules amendment was with respect to the expedited examination. Of course there may be other like, you know, minor changes in the rules, but the major ones are covered here. One is expedited examination, which was in 2019. The patent amendment rules in 2020, the first one, therein it was for the form 27. It was for form 27. The patent second amendment rules 2020, it was for fees for MSMEs and startups. And lastly, the last amendment that happened in 2021 was for the educational institutions. As a broader question, can you, like, you know, let us know about the amendments that happened in the patent rules, like, you know, in last 2-3 years? Then you can mention about these four actually, okay, with a simple one line or one word. I would say the 2019 one is for expedited examination, the 2021st about form 27, second about the fees for MSMEs and startups, and the 21 about the fees for the educational institutions as such. Now let us go through these one by one, like, you know, because it may also happen that once you have a general question, they may specifically ask about the 2019 amendments, or it can be a, it can be a direct question about, or like, you know, what were the amendments in the patent amendment rules 2019. Now in patent like, you know, amendment rules 2019, it was the practice before 2019 was, once we file the patent electronically, we had to submit the records, physical copies, the courier, through the post actually. Now under patent amendment rules 2019, the amended rules mandate that the patent agent shall file or leave, make or give all documents only through electronic transmission, duly authenticated, that means signed. Further, if required only, the original document shall be submitted within a period of 15 days. If required, earlier it was kind of mandatory to submit those documents within a specified period of time. Okay, so this was a major change, and honestly this change helped the patent agents a lot during the COVID situation, because the patent office was working and we had all these electronic filings, e-filings done, and there was no need of submitting the documents. Now second, now there was a major change in rule 24C, expansion of rule 24C. The IPO through this particular amendment added the applicants in the category, like, you know, for who are eligible for the expedited examination purpose. Therein who were all added? Small entities, C to F, okay, currently जो available है उसमें, okay, the applicant which are small entities. Now what is small entity and the documents required? I think we have discussed this again and again. The MSMEs and small entities are same, for your information. Like, you know, the female applicant one was also added through this particular amendment, that all the applicants are natural person and one of them is female. Applicant is a government undertaking, that was also added in this, and the applicant is eligible under an arrangement for processing an international application pursuant to an agreement between IPO with another participating patent office, what we also call at times as the patent prosecution highways as such. Okay, India has signed a patent prosecution highway with Japan actually. Okay, now based on this, as you know, the first amendment, okay, whenever any amendment happens, the forms get changed if required, and through this patent amendment rules 2019, the form 18A which is for the expedited examination, got amended, as well as Form 28 was also amended to get the benefit of this for the SMEs actually, MSMEs and SMEs actually, right? So the Form 18A and Form 28 were changed to include the above details in Patent Amendment Rules 2019. So the Patent Amendment Rules 2019 are about two things: the electronic submission of records and the physical file. I mean, it was like earlier electronic filing and submission of the record through the post. That second part is removed now. If required, only the original document need to be submitted. This you need to remember actually. And the second major amendment was applicants eligible to file requests for expedited examination. There was an expansion of Rule 24C. Okay, so this was the first amendment that happened into Patent Amendment Rules 2019. As I mentioned, it is about majorly about the expedited examination. Now, the second amendment that happened in 2020 was one of those, I would say, critical amendments that has happened in the Indian patent rules. There was lot of brainstorming happening at the policy level or the government level or the stakeholders level about the Form 27 actually. And in fact, when we were discussing this in class about the Form 27, what needs to be submitted, how it need to be submitted and all, therein there were a lot of confusions basically. And this changes, the changes in Form 27 as per Patent Amendment Rules 2020 made it comparatively easier to submit the Form 27. Firstly, earlier it was the calendar year. That means 1st Jan to 31st December of a particular year. For that, you had to submit the Form 27. Form 27 is your related to the commercialization of the invention actually. Now that has been changed to financial year. uh, this actually has a lot of impact specifically on the corporates who are submitting, because the financial, the all the calculations for a particular product or technology, it is very easy for them to do as per the financial years. In India we have this financial year system, 1st April to 31st March actually, like, you know, and all the disclosures by the corporates generally are through this particular financial year calendar only, and not as per 1st December to, sorry, 1st Jan to 31st. So it's not as per the calendar year. So this was a major change. And also now it has to be submitted within 6 months after the financial year, and that's what it makes it as 30th December as a deadline to submit Form 27. So 30th December is the deadline to submit the Form 27, whether that invention has been commercialized or not. And the significance of commercialization data or Form 27 is also with respect to compulsory licensing, wherein the any other applicant can basically use this data showing that the invention is not working, commercial working का जो clause है, like, you know, it's not worked in India. Okay, that is something which is a significant. Now the patent is worked, the approximate revenue value for the patentee or licensee is now must be mentioned into Indian rupees actually. The currency is specified now. Okay, this is as per Patent Amendment Rules 2020. The Patent Amendment Rules 2020 are more concerned about the Form 27, the changes in the Form 27. Also, single Form 27 for multiple related patents. Now, this was a big this was a big change, I would say, for like, you know, for the corporates, because if there is one tech product, let us think of any one product, it is covered by, let us say, 8 to 10 patents. Now at times it is very difficult to evaluate it, which patent covers how much revenue. Basically, let us think of mobile handsets generally, or the laptop, let's say. So many technologies, so many patents covering that, right? Now it is very essential, how are you going to evaluate a one patent related in the revenue is this. And the bigger problem, like for example, if I get the revenue of the entire product and I submit it into 20 patents, at the end of the day, the message going may be that, for example, if I have 500 CR revenue and I'm submitting 500 CR for 20 patents, it may be, actually, because this is the data that you are submitting to the government, right? So it may be construed as 10,000 CR is your revenue for that. So this ambiguity was there, and this ambiguity was removed because of this particular patent amendment rules, that is form 27, single form 27 for multiple related patents. Tricky thing was in case of joint owners or joint applicants for the patent as such, they had to submit it separately for the same patent earlier. Now there is single form 27 for joint owners of the patent, but for the licensees, individually they have to submit the form 27. When we say licensee, like, if there is an exclusive licensee, that's absolutely fine. But if it's a non-exclusive license, in that case, we have these options. And like, so individual licensee would provide you the, has to provide the form 27 actually. So this was the second change. When we think of the patent amendment rules 2019, it was for expedited examination. Patent amendment rules 2020, it was for form 27. Let's move on to 2020 now, wherein we had two amendments. Sorry, 2020, the second amendment was for the startups and MSMEs as such. Now, before these rules, there were 3 columns of fees actually. Before these rules, there were 3 columns of fees. First column was for the natural applicants. The second column was for the MSMEs and startups. And the third column was for the other entities. Now, for electronic filing and patent filing, basically first patent filing, the first column, the fees was 1,600 for e-filing, electronic filing. For the second column, for startup and MSMEs, the fees was 4,000, and the fees for others were actually 8,000. This I am speaking about electronic filing. This also reminds me of one thing. When you are asked about the fees, if there is a question anywhere about the fees, mandatorily 2 things you have to tell. First thing, it is for electronic or physical filing, and second thing, it is for the natural person or MSME startups or the others actually, right? Now there were 3 columns, and in this, under these rules, patents second amendment rules 2020, the middle column is no more there, and though there is a fees reduction for startups and small entities now, which is equivalent to the natural persons now. Remember that the rules, when they are implemented, thereafter only, if there is a new filing, those rules would be applicable. There is no, I would say, reciprocal, implementation. Before the rules, if someone has filed, they are not eligible for that concession in the fees action. So the patent second amendment rules in 2020 was about the fees for MSMEs and startups, which was actually reduced. And what was changed? The middle column of fees was actually abolished. So, and when I say middle column, for every row basically. So for example, for the patent filing, it was 1600, 4000, and 8000 for the electronic filing. Now it is 1600 and 8000 only. Same for request for examination, same for any other I would say row that are there in the forms and fees aspect actually. Okay, so this is about the patent second amendment rules 2020. There, the last amendment happened in 2021, and everyone knows it honestly, as well as this has been discussed a lot throughout I would say the our classes as well as various forums as well, because this actually had a mass impact as far as the practice of patent agent is concerned and the educational institutions are concerned. Under patent amendment rules 2021, there is a fees reduction for educational institutions by 80% actually. There is a fees reduction by 80%. Now, earlier, they were providing a fees. They had to pay a fees of 8,000 for the electronic filing, equivalent to the other person, that is corporates. That fees is now reduced to a level wherein the fees is as per the natural applicants actually, okay, or the startup MSMEs. So that is equivalent to individuals actually. What was changed in this? The changes are in the form 28 again. The form 28 now includes educational institutions as such, and this was one thing I believe which was also discussed during the class, specifically about the format of form 28, because those I would say the contents which were published before these rules have the form 28 format without the educational institution as such. Also, educational institution is like defined in rule, like and it means a university established or incorporated by an act, and includes any other educational institution as recognized by an authority designated by central government or state government or union territories in this regard. Now, what do you mean by this? Now, for of course, this educational institutions clause for the reduction in fees as per patent amendment rules 2021, for an Indian applicant, like any document as per the rule, I would say is rule 2CA, you can provide actually. It may be any affiliation certificate, or it may be any recognition of any government authority like AICT or UGC. That may be something which you can provide as a proof for like as a form 28 yeah. Now, in case of foreign educational institution, any other document, remember these amendments also allow the foreign educational institution to get that concession as well. One confusion everyone has, or not everyone I would say, but most of us have actually. This rules 2021 give you concession in the fees, but then they do not give you any eligibility under expedited examination under rule 24C. Don't ever get confused. If you are filing form 28, herein it is not for expedited examination eligibility. It is for the eligibility to get the fees reduction actually. This is important. Okay, the educational institutions which are government or government funded or autonomous, which are fully owned by government, are the ones who are eligible for the expedited examination only. The private educational institutions are not eligible for the expedited examination unless they file the PCT and select India as a ISA. Under that condition only they are eligible for the expedited examination as. So this concludes our part one. What I mentioned is 4 rule amendments in the rules. Amendment Rule 2019 about expedited examination, expansion of the scope. Patent Amendment Rules 2020 about the change in format for Form 27. The Patent Second Amendment Rules 2020 for the fees for MSMEs and startups. Patent Amendment Rules 2021 for the change in fees in the educational institution. There was a major change with IPAB and Delhi High Court Intellectual Property Division. In IPAB was abolished, and this February actually the Delhi High Court IPD was established. Just request to go through the video in the month of Feb that we have on the Pharma Literati YouTube channel, which mentions about these 2 changes. This concludes our first pass. We'll go to the case studies now with just a few seconds break. Okay, now we have got few cases which I have selected few interesting cases based on the concepts, based on the significance of those cases actually. And we are going to discuss just 4 cases today. There are 2 cases, the Union versus Union, Novartis versus Union of India, which is already discussed in the class for the section 3D. And I feel every one of you have actually gone through that. There was an interesting case between Ericsson versus Union of India about section 21, the applicability of the section 21. And this was for the appeals actually. This case was also discussed in the previous video that we have on the YouTube channel. Another case about the compulsory licensing, the only compulsory licensing we have got till date for the case Bayer versus Natco. That was also discussed in that video actually. So I'm not going to discuss these 3 cases. Rather, I have got some interesting cases which are from different domains, I would say. Of course, like, most of the people say all my cases are generally with respect to pharma. There is a reason for that, since my practice has been into the life sciences or pharma. And beyond that, actually, if you see the kind of cases we have, most of the cases are more into pharma actually. And of course, now we have got the telecom industry, which is very active, or randomly we have other industries as well. Like we had this very famous case of Bajaj Auto versus TVS Motors as well, which was from the automobiles industry. But we'll try to understand these cases in the context of general, I would say, everyone, rather than let us not categorize them as per the industry basically. The first case, Philips versus Rajesh Bansal and Bhagirathi Electronic. This is for something called as a standard essential patent. It is the first case actually in India about the standard essential patents. Now it's an interesting case, but before that, I also want to let you know, especially those who are from this domain actually, what is a standard and what is a standard essential patent actually. These 2 things you need to understand before understanding this. Standard, like for example, the USB slots in any laptop or any device basically. Now these slots are of a specific configuration irrespective of what technology is there in the laptop, or irrespective of what laptop you are using, the Apple, the HP ka hai, Dell ka hai, koi bhi use karo. That means there is a standard with respect to that. Okay. Now who sets the standard? There are SSOs which we call as standard setting organizations. SSOs are the ones who create these standards, right? And these are followed by all the industries basically. There may be standards for the mobile handsets, the laptops, any electronic devices basically. And that's the reason we are able to access all these devices as well very smoothly basically. Imagine if there is no standard, then probably there would be so many variants and it would be very difficult to operate. That interoperability is something which would be very critical as such. And that's where the term standard comes into play. Now, what is standard essential patent? What we call as SEP. Now, if that particular thing which is a standard, okay, what is SSO is setting as a standard, and if there is a patent existing, and without using this patent, you cannot use that standard. In that case, this is called as a standard essential patent. The patents that are required to carry out the or use that standard basically. Now, on one side, there is a standard which is required for you to operate in that electronics, let us say the DVD domain. And on the other side, that standard is basically patented. That means by default, you will have to go for the licensing. That is what is called as standard essential patent. And that's the reason these are the common terminologies, the standards, the standard essential patents in the entire electronics industry as such. And most of the times, the companies who are who own the standards, okay, or the patents for those standards, not the standards but the patents for those standards, we may not know the name of those companies as well. The names that we actually see, the hardware companies and the electronic gadgets and devices, these companies take the license from these companies, the one which own the patent basically. Now, an interesting case happened. This is a patent for by the company Philips on channel decoding technology used for DVD video playback function in a DVD video player. Honestly speaking, what is the technology? I'm not from electronics domain. I may not be in a position to understand. What I want to inform every one of you here is that in this case, this was a standard basically, and this standard, the without using the IN 184753, you cannot perform or use have your device in the market. There were two players actually. The Rajesh Bansal and Bhagirathi Electronics were the defendants actually. They were the ones who were uh, like you know uh, who were actually engaged in the manufacturing, assembly and sell of DVD video players under various brands, which essentially required or employed the decoders as per the 184753. There is a party who owns a patent, that is Philips, and there are a couple of players who are manufacturing the devices now. And without infringing, so Philips believe that there is an infringement of the patent because they are manufacturing and selling the product per se. Now, what happened in the case actually is the defendants, of course, the moment we speak about these devices, electronics and all, they mentioned that the patent is mere an algorithm. The common clause that is in this industry, the subclause section 3K actually, the contention of the defendant was that the suit patent pertain to an algorithm and is not an invention under section 3K basically, right? Now, section 3K basically. But then the defendants didn't provide any pleadings or evidence during the written statement in the court actually. Now, therefore, there was no issue basically, and the validity of the patent were decided in favor of the plaintiff, that yes, the patent is valid. Or remember, the patent was already granted as such. I've got a couple of questions on the YouTube chat box. The validity of standard essential patent and term of those SCPs. I think these are more legal matters, Subhashri, and I think we don't need to delve into more details as well. I'm not an expert to comment in this particular domain. Let us just focus on this case. My target herein is basically to prepare you for Viva. Probably these kind of policy questions, the one which you asked, the validity of standard essential patent or a term of those SCPs basically is a more policy perspective, and like I think these kind of questions, I'm doubtful if these questions would be asked unless you are an expert in that domain in the Viva basically. Okay, coming back to the case, essentiality of the patent. Now the defenders argued, and this was an interesting argument. Defendants, both the parties, Rajesh Bansal and Bhagirathi Electronics, they argued that the standards were internal documents of the plaintiff, and then the defendant need not follow those standards basically. But this was rejected because the standard setting organizations have the standards were in public domain. Rather, one of the defendants had previously taken a license in respect of a suit of patent from Philips actually. So one of the defendants had already taken the license. So it was the defendants knew, the conduct of the defendants clearly proved that they knew that these were essential patents, right? And there was a specific mention then the DVD forum standard, whatever number they are providing here, that yes, the essentiality of patent means yes, these are standards and these patents are covering that standard, because these are also two important things in any SCP basically, right? So the first question, section 3K, was in favor of the patentee actually, that the patent is valid. Remember, it was already granted, and the defendant didn't mention anything about the section 3K in terms of their written submission. Essentiality of patents: is the patent essential? Yes, it is essential. Is it a standard? Yes, it is a standard. Now the third part, and important part, and I think this has been about more about the infringement actually. Okay, the defendant submitted that they assembled the DVD players with parts purchased from the legitimate sources, including the chip from some other country. Okay, but then they were accordingly they were not liable as per, because this was more of a parallel import, and they were not liable for infringement basically. So they had got legitimate the parts and they have just assembled it, but the defendant couldn't prove that, they failed to prove that it was obtained through legitimate sources as such. So accordingly this contention of non-infringement under parallel import was also knocked down, and it was held that the patents are infringed. Now, for those who are from this domain, electronics, telecommunication and all, there is a term called FRAND, that the royalty rates are fair, reasonable and non-discriminatory, right? And the defendant, now there was a contention about the rates, terms of the royalty as such, and but again, as the actual damages were not set out because of the lack of sales data provided by the defendants. The court appointed a local commissioner to ascertain the exact quantum of damages. This was for the damages. For the royalty, the one which Phillips mentioned was accepted actually. Here it was a clear-cut case. The significance of the case is with respect to, this is the first case of SCP litigation, standard essential patent litigation, wherein Phillips sued these two parties. Okay, the contentions were with respect to section 3K, section 3K, wherein since it was not provided, the arguments were not provided. That's the reason the patent was held valid. It was also about the infringement. Infringement was proven, and the important part, are these essential standards? Yes, they are. It was standard, and it was an standard essential patent as well. Now, this is the first case which we discussed about the standard essential patent. If you mention in your Viva that you are from the electronics telecommunication this domain, this may be a question asked to you, or it may also be a question if the controller or examiner, whoever is taking your Viva, they are from this domain. Remember this. Next case, an interesting case. I have been repeating this, that there is only single compulsory licensing case till date in India, and but I think in last few days itself, this case came up. It's not a case basically. It's a verdict or direction by the Kerala High Court about a drug called ribociclib, and they directed the DPIIT, the Department for Promotion of Industry and Internal Trade, which is under the Union Ministry of Commerce and Industries, to pass an order to issue after consulting the relevant authorities for issuing the compulsory license under section 92 and section 100. Now, the case is, it was by a retired bank employee wherein who was diagnosed with the breast cancer, undergoing therapy. The petitioner said that the treatment involved 3 drugs a month, totaling 63,000 rupees. Out of this, the cost for ribociclib alone is 58k, and her pension is around 25,000 only. So she wanted that. The pricing is high, and the Kerala High Court accordingly directed the DPIIT. Now, what is section 92 and section 100? Section 92 is the one wherein which empowers the central government to issue compulsory license subject to 3 conditions. That is a national emergency. The requirement is extremely urgent, and it must be for public non-commercial use. And as per section 100, any person authorized by government is empowered to use the patented invention for the purpose of government. Now, if you look at section 92, there are 3 conditions. Circumstance of national emergency. Doubtful whether this case would be something which can be considered as a national emergency. Okay, of course, that's my personal I would say opinion, but in as far as the case is concerned, it may be more of a circumstance of extreme emergency, or and case of public non-commercial use is something also which may be involved in this particular case, wherein the individuals actually wants that particular medicine at a cheaper price once the compulsory license is granted. This is a recent happening, and as I said, the compulsory license that was granted for the other drug, the single compulsory license till date that has been granted, that's a very old case. And if something new has to be asked, this may be something you just need to mention under section 92. Remember section 92 under, so that case, the Natco buyer case, was about section 84, wherein the applicant Natco had asked for a compulsory license under section 84 under 3 separate provisions. They proved it and they got the compulsory license for that, right? So this is about the ribociclib. Third, a very interesting case which impacts I would say the entire patent agent community. And this has been again widely discussed and debated in all the forums, the European Union versus Union of India. Now, there were certain applications which were filed by a patent agent in India. Okay. And those applications were abandoned due to missing the deadline to reply FER. If you look at section 21, if you miss the deadline for filing the FER reply, then in that case like in that case the application gets abandoned. And remember this Ericsson case, this was challenged because instead of refusing, the application was abandoned as per the control. So this is not appealable now. But the problem herein was that the patent agent did not file any reply, although the applicant was following it up with the patent agent. Applicant was trying to follow up with the patent agent to submit the reply. Now, the interesting thing actually had happened in Europe during that time, that so there is a law firm who had given the work to first patent agent, okay, and thereafter the the first law firm had transferred the work to the second law firm. Now the second law firm was following with the first patent agent, of course, automatically, because all the work is transferred now to the second law firm. Now it was after there was no response by the first patent agent, the European law firm hired another patent agent. The second patent agent addressed multiple emails to the patent office seeking a hearing. The second patent agent addressed multiple emails to the patent office seeking a hearing after the abandonment. But there was no response. There was a writ petition thereafter filed in Delhi High Court. The primary ground was that delay in the filing responses to FER was not attributable to patentee or the applicant, basically. Okay, the writ petition was filed that the delay was not from the applicant, but it was from the first patent agent, basically. Right now, herein the as a proof, they also submitted the communication that they had with the first patent agent to follow for the replying the FER, basically, as well as they also were in a position to show that the equivalents of these applications in other countries are already under prosecution or are granted, and there was no sense to get them abandoned in India. Right? The council on behalf of patent office argued that if prescribed time period as per patent rules 2003 has elapsed, including the time frame for filing a response to FER, same can't be extended thereafter. This cannot be. But then the court directed, or the verdict was that it actually extended the deadline for filing response to FER in these applications. Actually, extraordinary circumstances in the form of negligence by the patent agent. 3 conditions they have mentioned: negligence by the patent agent, docketing error, and whether the applicant had been diligent in prosecuting the application. If these 3 conditions considered as extraordinary conditions are there, then in that case the deadlines can be extended as such. Remember, the controller has discretionary power to extend the deadlines up to 1 month, but then in this specific case, the council from the patent office was key. It cannot be done extended thereafter. So this case is very interesting for the practice of a patent agent as such, and I believe this is a very recent one in last 2-3 months. I believe you need to understand, you need to know this because this is directly connected to the patent agent's practice. Moving ahead, but before that, I have a question here from Apurva. Can the employee be person interested? Because only person interested can apply for a CL. Employee of a company, as an employee, he may not be considered as a person interested. on behalf of the company, if he is willing to do that, Apurva, then probably there is a chance to prove that person interested as such. Okay. Now the next case is very old case, I would say. This, I remember an article I had written long back, almost 10-11 years back, about a concept called as a drug patent linkage. I've selected this case from pharma domain again for the drug patent linkage, because this has a wider impact in terms of understanding of the patent and the regulatory affairs. Actually, there was a patent granted for sorafenib tosylate. Bayer was the assignee, and Bayer actually, uh, Bayer, what they did is, like, they approached the DCGI. They filed a writ petition restraining DCGI from granting a license to Cipla. What does it mean by that? Now Bayer is a patentee. Bayer's product is there in the market. Bayer is a patentee. Bayer's product is there in the market. Cipla is asking for a DCGI approval for manufacturing and marketing. Now the Bayer as a company wanted the DCGI not to grant the approval because the product is patented. That means, so this is the typical scenario, what we call as a Bayer, the drug patent linkage. Actually, the drug patent linkage, actually, that if there is a patent granted, so this is common in US, like US FDA doesn't grant you approval unless and until the patent is expired. But that's not the scenario in India, actually. And those of you who had attended the classes, physical classes in Mumbai and Delhi, we had discussed this very interesting case of Merck versus Glenmark about sitagliptin, wherein we discussed about there is no drug patent linkage, and so exactly this was the first case wherein the court rejected Bayer's arguments and confirmed that in India there is no patent linkage regulation, and there is no intent basically to link the two legislations as well. So there is no explicit, there is a specific legislation required for the patent agent or the patent linkage as such, so since there is no legislation, DCGI can grant the marketing approvals under DCA to generic version of the patented drugs. Determination of patent infringement is exclusive jurisdiction of court, and it is beyond DCGI. DCGI cannot actually give the verdict about whether the product is infringing or not as such. Now this was something which was actually discussed in this particular case. So we discussed this Philips case, the ribociclib compulsory license, the European Union, and finally the drug patent linkage case. These four cases I wanted to discuss. There are a couple of more about the patent infringement, but before that, let me take these questions. Is there any CL granted on 92A? Rakshit, as far as my knowledge is concerned, there is not a case on 92A, but please, this is not a legal opinion. Just check it once. I don't think it is there. Apurva's question is interesting again. The retired bank employee would be considered as a person interested, actually. Apurva, the person interested term under section 84, person interested term under section 84 is different. Under section 84, actually, you need to have be a person interested. Herein, the employee is not, the bank employee is not a person interested. She has filed a writ petition, or she has filed a case in court that the court directs the central government to give the compulsory license. And as a patient, as an individual, you can definitely do that, actually. That is something which is very important to understand as such. So the person of course, you can file a lawsuit for sure. Nothing stops you from filing a lawsuit as such, like, in this case. Now, there is Harsh Parekh is the case of FERID Alani versus Union of India. Important. I'm extremely sorry, Harsh. I'm not aware of this case. I shouldn't comment on this. See, generally, what we call as important cases, I would say, is the one which has a wider impact actually. Like, generally these are like, in terms of practice of an industry or practice of patent agents, or for that sake, anyone as such. Like, now, so that's my comment here. So there are a couple of cases on patent infringement. First, Roche versus Cipla, and I think Dr. Rahul had discussed this specifically during the Viva voce sessions, that we should discuss Roche versus Cipla. This was an interesting case in terms of patent infringement actually. Like, of course you can just search or Google it out. You would get a lot of details actually, but it's an old case actually. In Roche versus Cipla, it was about the infringement actually. What had happened is Cipla was marketing some other form of drug which was not Roche's product. That means Roche is selling some product and there is a patent existing actually. Okay, the one which is patented and the one which is sold by Roche, there is a minor difference actually. And Cipla was trying to compare, trying to map Cipla's product versus Roche's product. That was a major thing. Cipla's products versus Roche's product. Now, and this, in fact, I had told in the February session as well with respect to the analysis of infringement. Yes, it's erlotinib. Thank you, Twilight BTS. It's for that particular molecule. Now, in case of infringement, it is never about innovator product or the patentee product versus your product. Rather, in case of analysis of infringement, it is always patent versus your product. Patent versus your product. Mapping of claims versus your product. What is there in the market for like, that is absolutely different thing. And in this case, Cipla infringe the patent basically for the drug like, erlotinib as such. I've got a couple of comments here in the chat box. In Cipla versus Roche, there was a decision by a single judge bench that injunction can't be granted because of public interest. Rushikesh, this was a early stage like, details that you have read. Injunction was not granted, but at the end, injunction happens at a very early stage, right? Looking at the so injunction is a completely separate thing, Rushikesh. The end verdict of infringement was in favor of Roche. Till that time, Cipla was in a position to sell the product. Whatever is there in the market, they were able to actually sell. There is no withdrawal of the product from the market for Cipla, but definitely like, definitely the product was there, but then Cipla is infringing. They had to pay some damages as such. This is about Roche versus Cipla. I have got a comment here, Hitesh. So the CL has granted on no. CL has not been granted. Kerala High Court has directed. Hitesh, Kerala High Court has directed the DPIIT, Ministry of Commerce and Industry, to pass an order, CL, to pass a CL based on after consultation with relevant authorities. Before that, they can't actually do that. Okay, so there is no CL order mentioned as such. Now, I also have a question from Kaushik Bera here. Under 24C, institutions established and controlled by the government, institutions established and controlled by the government are eligible. So educational institution, absolutely yes. IITs are eligible to file Form 28, and Form 28 for getting the reduction in fees, the concession. See, Form 18A, Kaushik, is optional. It is not mandatory, na? Right? If they want, they can actually file that actually. Another infringement related interesting case, just Google it out. You would get some details. Bajaj Auto versus TVS Motor. There were two separate lawsuits. In one, Bajaj, the patentee, had filed a lawsuit for the infringement of its technology by TVS Motors. In other lawsuit, the TVS Motors has filed for a lawsuit for what you call as the declaratory judgment that there are unlawful threats for infringement of patent. Class, if you remember the infringement class that we discussed, जो session infringement का था, therein we had discussed in detail about the declaratory judgment from the defendant's end. The alleged infringer basically asks the court to give a declaratory judgment that the Bajaj won't file a lawsuit. Now these both cases were simultaneously they were parallel cases actually, and so it was also about patent infringement. Whether infringement was proved or not, just search it out, and if someone is knowing this, put it in the chat box. But what happened at the end in this case is that they had actually settled both the cases out. So it was a out of court settlement as such. Okay, for these both the cases as such. Okay, so this is exactly, these are a few cases, and I believe that this would be something which may be useful for all of you for next 2-3 days when you are appearing for your Viva. Be at your best. All the best for your exam. It's gonna be easy, and for sure I would say that the way you have prepared for the exam, just last 2-3 days, just revise whatever possible. Don't get panic. It's not an interview basically. It's not something there for, I would say, to fail someone, I would say. Rather, it would be a mere discussion, the way we had the conversation during the mock Viva voce, and it should be simply I would say the way you deal normally with the people, accordingly you can appear for the Viva. All the best. It was really pleasure to be with all of you since last almost 6-7 months. I'm this is last session, live session as well for the patent agent exam 2022. It's been a journey wherein a lot of people were with me. I got some employees as well for my organization through these patent agent classes. I got a lot of good friends, I would say. In my career, I always believed in reverse mentoring. I got a lot of good students who helped me understand a lot of different aspects. And not to forget Hitesh Chabra, who is right there as well. Everyone, thank you so much. Any questions, I'm available or you can get connected with me via phone call or WhatsApp. I'm available, and all the best. Very soon you are going to call me in the month of August, telling me that you have cracked the patent agent exam. And that point of time, for sure, with sweets, also with the party, will be meeting very soon, one-to-one. Thank you everyone, and have a great day, great Sunday.